After more than a year of waiting, landlords in California are finally able to take their tenants to court over missed rent payments as the state lifts its ban on evictions. Some cities and counties will still have some safeguard for renters, and the state will also keep some safeguards in place, all tied to billions of dollars in rent relief that the state is urging landlords and tenants to apply for. Remember, 724,000 California households are behind in rent some $2.5 billion. And some advocates are warning of a wave of evictions. Now, quick disclaimer here, I am not a lawyer or a legal professional, so make sure that you always obtain legal advice when necessary about the subjects contained in this video. So here's what you need to know about the state's eviction laws moving forward. Hi, this is Kiwi the Coast, your luxury real estate specialist, helping you maximize and sell the value of your coastal home. And if you're new to the channel, don't forget to subscribe. Let's jump in. So you just received a 3-day notice, pay or quit, from your landlord. So what do you do next? So under the current law, when you receive a 3-day notice to pay or quit, now the first step in the eviction process is that the landlord has to wait 20 business days, not calendar days, 20 business days before they can take you to court. It's a defense in court if you tell your landlord that you have filed for rent relief within 15 business days of receiving that 3-day notice. You'll also have to give your landlord a signed declaration of COVID-19 related financial distress. That's within 15 business days of receiving your 3-day notice. The court will also ask landlords, under penalty of perjury, whether they applied for any rental assistance. The landlord will only be able to move forward with the case if their application was denied. If 20 days passed and you did not submit your rental relief application or didn't notify your landlord that you applied, they will also be able to move forward with the eviction process. Okay, so I received an eviction notice. What should I do? If you received an unlawful detainer or eviction notice, don't leave the home right away. And this is what the experts urge. In California, your landlord cannot kick you out of your premises until your court case process is complete. Then only by action from the sheriff's department that they can lock you out. Now, there are plenty of free legal services to help walk you through the court process or even represent you. Tenants Together, an advocacy organization, has a list of resources, as does the state. Now, if you live in Los Angeles, check out stayhousedla.org. You can also text RENT to 211-211 for help from United Way, a non-profit that helps distribute rental relief. Some cities are also staffing up to help tenants facing eviction. For example, in Fresno residents can contact the city's attorney's office and apply for the Eviction Protection Program. Hey, my court date is coming up. I don't have legal representation or an attorney. What should I do? Take advantage of the defenses that are afforded to you by the law. You still have to show up in court. The state has a guide for representing yourself. Many legal aid and housing organizations have other legal resources that you can take with you to help you in court. There are also self-help centers to help you with filling out of the paperwork, as well as free mediation services available at many courthouses. Now, my landlord received rental assistance, but he's still evicting me. Now, is that legal? A landlord who received past rental assistance may still be able to take you to court for not paying your full October or subsequent month's rentals, which of course now will be due in full. The landlord will still have to follow, though, the rules of the rental relief program. You can still apply for up to 3 months of rent moving forward, provided that you haven't maxed out on the 18 months of rental assistance, which would shield you from eviction. So what reasons can a landlord still evict you other than for not paying rent? Since the start of the state's eviction protections, evictions over unrelated rental issues have been ongoing. Evictions over issues unrelated to rent payments have been ongoing. A Cal Matters analysis found at least 10,000 through March 20 21. And those reasons include, so the first one was a landlord or their family was intending to move back into the property, or they were intending to sell to a person that was intending to move in. Now the next one was a landlord was having to do a substantial remodel or even demolish the property because it was becoming a health and safety risk. Third one was the tenant had committed a crime or a criminal threat on the property. Final one, the tenant had either subleased the property, created a nuisance, or had stayed long after the lease had expired. Hey, I hope you found all that information valuable. Now don't forget to subscribe to my channel so that you can stay up to date on all these matters affecting evictions, the matters affecting you and the real estate market. See you on the next video. The Room.